Okay, I think it's 9 o'clock. Good morning, ladies and gentlemen, and welcome back to the second half of our business rescue workshop. Um, we are going to do the second half of your study unit, in other words, from study unit 5 to study unit 10 today, following the same approach as yesterday. In other words, I will go through the study units until 11 o'clock with a short comfort break at 10 o'clock, just for 10 minutes or so. Then I hope to finish around 11 o'clock. And then I will give you the opportunity to ask questions. Now, yesterday I asked you to put up your hand or to use the hand function when you want to ask a question, but that didn't work so well. So I suggest today, if you want to ask a question, um, you must make a note. You must use the chat function for that. If your question is too long to type out in full, just make a note there. I want to ask a question. That's all you have to say. And then when it's time for the questions, I will actually go down the list and I will give you the opportunity to ask your question. I think that will work out better. And as I say, you won't have to write down the whole question. You can just make a note to say you have a question to ask, and I will give you the opportunity to ask that question. Okay, so let's start straight away. We are now at study unit 5. The business rescue practitioner qualifications and appointment. Obviously, the business rescue practitioner is the most important person in this process because it's up to the practitioner to make a success of this business rescue and to achieve the goal, one of the two goals of business rescue. Now, I don't think I have to say a lot about qualifications. Um, the important qualifications, of course, are that a practitioner has to be a member of an accredited professional organization. At this stage, there are 11 such accredited professional organizations. There is a list available on the CIPC website of all the accredited professional organizations. Um, and then the second thing is you have to get a license from the CIPC to act as a business rescue practitioner. Um, they require you to do that through your professional organization because, among other things, you need a certificate of good standing from your professional organization to be licensed as a practitioner. Um, in the early days of business rescue, the CIPC also issued licenses directly to people who did not belong to a professional organization because it took about 2 or 3 years, if not more, to accredit the professional organizations. But now it is an absolute requirement. You must belong to an accredited professional organization and you must have a certificate of good standing from that organization, and you get a license for 3 years. After 3 years, or slightly before that time, really, you should apply for your license to be renewed again. You have to submit certain documents again, and then your license will be renewed for another 3 years. Um, Unfortunately, in South Africa, it's not. You are, of course, it's a contravention of the Act to act as a business rescue practitioner without a license. Um, but it is not as, for instance, in England, where it is a criminal offence to act as an insolvency practitioner, including then as an administrator, which is their version of the business rescue practitioner, without a license. So you can be criminally charged if you act without a license. Um, Okay, so the various professional organizations obviously have their own requirements for membership. So it will depend on which professional organization you belong to. You know about the classification of practitioners in three classes: senior, experienced, and junior, based on the number of years of experience that you have. As in the turnaround industry, not necessarily as a business rescue practitioner. Um, the CIPC recently complained that they are increasingly getting appointments of junior practitioners for companies that they are not qualified to act for, because a junior practitioner may only be appointed for a small company, and the classification of companies into large, medium, small, that's based on the public interest score of the company. And they say that junior practitioners are accepting appointments for companies that they are not qualified to act for, because it's, for instance, a medium or a large company. So it is up to the board of a company, when they appoint a business rescue practitioner, to make sure that this practitioner is actually qualified to act for this company. And if not, that could be regarded as a breach of the duty of care and skill of directors, and they could be held liable for that. So it's very important, and it's up to the company, if they nominate or appoint the practitioner, to make sure that they appoint somebody who is in the right classification. As I said yesterday, 91% of all business rescue cases commence by way of a resolution filed with the CIPC. So in the vast majority of cases, it would be the board of directors or the managing members of a close corporation who appoint the business rescue practitioner. Now, especially when business rescue was still new, some boards were company boards were quite shocked to find out that although they have the authority to appoint a business rescue practitioner, if the business rescue is commenced by the filing of a company resolution or a board resolution, they do not have the power to dismiss or replace this business rescue practitioner. They have to go to court. So you need a court order to replace or dismiss a business rescue practitioner. The independence of the business rescue practitioner, of course, is also important, because the business rescue practitioner is supposed to act in the interests of all the affected persons, and not just one affected person or one group of persons. You will see we have a number of cases on the removal and replacement of a business rescue practitioner. Now, the strange thing about the replacement or the removal of business rescue practitioners is that Section 139 states that a practitioner may be removed only by a court order or as provided for in the section, which is also by way of a court order. But then in subsection 3 of Section 139, the Act states that if the practitioner dies, resigns, or is removed from office. Now, that's the only place in the whole of Chapter 6 where the possibility of a practitioner resigning from office is mentioned. There is no indication on what grounds such a practitioner may resign, when, nothing. There's no procedure, no forms, nothing. It is the absolutely only place where this is mentioned. But we must assume that because it's mentioned, it is possible for a practitioner to resign. And then in that case, we have to, the practitioner has to be replaced either by the affected person who nominated this practitioner when in a case where the business rescue was commenced by an order of court, or otherwise, if the practitioner was appointed by the board, in the case of commencement by a board resolution that was filed with the CIPC, then the board has the authority to appoint a new practitioner. We actually have a fairly new case, which is mentioned in your study guide, TIOP versus Shiva Uranium, where the practitioners decided that they have the right to appoint their replacement when they resign, or maybe the remaining practitioners. The court made it very clear that they do not have this authority. If a practitioner resigns, then the creditor who nominated the practitioner originally, if it was an application to court, may now be nominated person. Now, the Act says the creditor who nominated the practitioner, but we think that was a mistake. They probably meant to say the affected person who nominated the practitioner, because the point is that not necessarily in all cases would it be a creditor who applied to court for a business rescue to commence. It could have been a shareholder or a trade union. So it is the affected person who originally nominated the practitioner when this person applied for the business rescue order, who now has the right to not to appoint a new practitioner. If the business rescue was commenced by way of a filing of a board resolution, then it is the board that has the authority to appoint a new practitioner. However, if you look at Section 130, which deals with the setting aside or the removal of a practitioner, there the Act states the opposite. It says there the court must appoint a new practitioner recommended by the independent creditors. So it's not clear which one is which. So we must assume that if the practitioner is removed in terms of Section 130 by the court, then the independent creditors must, or the applicant must nominate a new practitioner, but this person must be recommended or must be acceptable to the independent creditors. While if the practitioner is removed in terms of 139, then it is simply the affected person who nominated the practitioner originally, or the company. Then in the case of a commencement by way of a filing of a board resolution, it would then be the board again who has the right to nominate the new practitioner. So there's a difference. In terms of Section 130, it would be the court on the recommendation of independent creditors. If it's in terms of Section 139, apparently it's the board that has the right to appoint the new practitioner again. So there seems to be a difference. It's maybe a conflict, or maybe it just depends on which section you use to remove the practitioner in the case of commencement by way of a board resolution. We have quite a number of cases on the removal of practitioners. For that, we have to thank the Gupta family, because they tried to remove practitioners in just about every company in the Oak Bay group that had been appointed. Although in most cases they had appointed these practitioners themselves, but they expected the practitioners to follow their instructions, and when the practitioners didn't do so, they took them to court and asked for their replacement. In your study guide, there is a reference to Oak Bay Investments versus Tegeta Exploration and Resources, where the application was based on an alleged conflict of interest because these practitioners were appointed for more than one company in the group. The court dismissed the application for their removal because the court said it doesn't automatically mean that if you are the business rescue practitioner for more than one company in the group, that there is a conflict of interest. The facts of each matter would determine that. This case was confirmed on appeal by the Supreme Court of Appeal. Actually, it was just an application for leave to appeal, which the SCA dismissed on the grounds that there was no reasonable possibility of the appeal succeeding. And here again, the SCA said, being the business rescue practitioner of more than one company in the same group does not automatically indicate a conflict of interest. The SCA pointed out that when you look at the grounds for removal of a practitioner in Section 130 and Section 139, they all seem to point towards a personal quality of the practitioner. In other words, there is something wrong, or there's a conflict of interest or a lack of independence on the side of the practitioner. So where you have a conflict of interest between two companies in the same group, the court was not quite convinced that this would be regarded as a conflict of interest in any case. They believed that it was more when there's a conflict of interest between the practitioner and the interests of the company, not between two companies. However, the court did say that if the conflict of interests between two companies in the same group where the same practitioner has been appointed, if this conflict becomes so serious that the practitioner is no longer able to fulfill his duties and do his job, then the practitioner should resign, not just from one, but from both companies. But in this case, the court said that there was really no conflict of interest at this stage. There was really no definite or no evidence of a conflict of interest. Then another Gupta case. This time it was Mrs. Gupta who applied for the removal of the same practitioners in two other companies in the Oakbay Group. Now, what is slightly disconcerting is that it was heard by a full bench of the Gauteng Pretoria High Court, and the application succeeded. They removed the two practitioners because the court said there was a lack of good faith by the practitioners, failure to perform their duties, and a conflict of interest. And in addition, the court attached great importance to the fact that the practitioner is an officer of the court, so there are higher standards for a practitioner to adhere to. This judgment was overturned on appeal by the SCA, and the SCA was very, very critical of this full bench decision. The Supreme Court of Appeal said that the allegations of abuse or lack of conflict or lack of good faith, they were all very vague. There was nothing specific about these allegations. The court relied on vague allegations without any evidence of specific instances where the practitioners did not fulfill their duties. And the Supreme Court of Appeal also said that if you base your application on the failure by a practitioner to perform his or her duties, you have to specify this practitioner did not hold creditors meeting as required. This practitioner did not do the following. In other words, there must be specific evidence of very specific statutory duties that the practitioner has and that he or she did not fulfill. You cannot just make vague allegations of a lack of or that the practitioner did not fulfill his or her duties. Then the Supreme Court of Appeal referred to this provision in Section 140, subsection 3, that a business rescue practitioner is an officer of the court. And the Supreme Court of Appeal said this is a very mystifying provision because in most cases, the court is never involved in a business rescue if it's a voluntary business rescue. And to say that they are officers of the court is meaningless. It doesn't add anything to their duties or responsibilities. Our law is quite clear, our common law, that if you are in a position of trust, which business rescue practitioners obviously are, then you always have to act in the best interests of the person in whose interest you should act. In other words, your position of trust. You don't really need to be told that you're an officer of the court and you have to report to the court. It doesn't mean anything. It doesn't add anything. We know that a person in a position of trust has fiduciary duties towards the person in whose interest he is acting. So really to say that they are officers of the court doesn't really mean anything, because once again, as I said, 91% of business rescue cases are commenced by way of filing of a board resolution, and unless somebody goes to court for one of the grounds or one of the possibilities in the Act, the court will never even be involved in the activities of the business rescue practitioner. And there's no provision anywhere of how do you report to the court, or where do you report to the court, or what do you report to the court. You report to the CIPC, yes, on the if the business rescue has not ended within 3 months, but there's no provision for how do you report in a voluntary business rescue? How do you report to the court, and what do you report to the court? So it's meaningless. And yet, in spite of that, you still find that many courts still refer to this provision that a business rescue practitioner is an officer of the court and is held to higher standards, professional standards, than would otherwise be the case, in spite of the fact that the Supreme Court of Appeal very clearly stated that it doesn't really mean anything. Okay, so I think that's about it that I wanted to talk to you about. So the most problematic thing about the business rescue practitioner is really the whole issue of a removal of a business rescue practitioner. Who can do it? Who appoints the replacement, etc. And then obviously that we must assume that a business rescue practitioner can resign, which is not really perhaps such a good idea, because it means that when the business rescue practitioner wants to take up another appointment, or gets bored, or finds that it's too complicated, then he or she can just resign, because the Act doesn't regulate the resignation of practitioners. So you don't have to give reasons. There is no proper formality that you have to comply with, no forms to complete. It doesn't even require you to inform the CIPC. But obviously, when the nomination of the appointment of the replacement business rescue practitioner comes to the CIPC, and the previous practitioner did not inform the CIPC that he or she has resigned, they will ask, well, what is the situation? You've already got a practitioner. Okay, so for in the interest of the practitioner, it would be best to immediately inform the CIPC that you are resigning. But clearly, then you don't have to even give reasons, because the Act doesn't require anything from you. When we go to study Unit 6, the powers, duties, and liabilities of the business rescue practitioner, you'll see that a business rescue practitioner has the same responsibilities, duties, and liabilities as a director of the company, as set out in Section 75 to 77 of the Act. And again, in the Knoop versus Gupta case, the Supreme Court of Appeal described it as an unfortunate legislative shortcut. Basically, the drafters of the legislation were too lazy to come up with the specific duties, fiduciary duties for business rescue practitioners. So they simply took over the ones for directors. And as the SCA pointed out, the directors are still there. It's not as if the business rescue practitioners now become the directors of the company. They are just supervising the directors. And they do have certain management functions, but they are not the directors. So to make them subject to the same fiduciary duties and duties of care and skill is really not appropriate. They should have had their own very specific duties of care and skill and fiduciary duties. And it is quite a problem, because it's very difficult to establish whether a business rescue practitioner has actually breached these duties, because these duties were drafted for the purpose of directors and not for business rescue practitioners. So again, the court, as I said before, said that you're in a position of trust as a business rescue practitioner. So that automatically means you must act in good faith and avoid a conflict of interest. That's in terms of our common law. You don't really need to import the fiduciary duties and duties of care and skill of directors. That was completely unnecessary. Also, you have to remember that a breach of duties is not in itself a contravention of the Act. Some people still try to hold the directors liable. You can't do that. The company itself can hold directors liable for a breach of their duties, but not a shareholder or a creditor. So it really complicates matters to make a practitioner subject to the same duties. Your study guide mentions section 218(2) of the Act. This is a very, very wide provision. It basically says that anybody who contravenes the Act can be held liable to anybody else who suffered damages as a result. Now, the courts don't like this section because they say it's too wide. Anybody, firstly, also, what is a contravention of the Act? Is it only a contravention if it is criminalized in the Companies Act? And then you will have a problem because there are very, very few criminal acts in the Companies Act, the 2008 Act, because it was a definite and very specific intention to exclude as many criminal acts as possible from this 2008 Act, because it was felt that the Companies Act is not the appropriate place to have criminal acts. So instead, they replaced criminality with liability for damages. So you won't find many criminal acts or criminal offences in the Companies Act. That's the first thing. So if you say, well, it doesn't have to be a criminal offence to be a contravention, then you have to start looking at all the duties of boards and everybody else in the Companies Act. When is that a contravention of the Act if they don't fulfill this? For instance, if the company doesn't submit its annual return, is that a contravention of the Act because you didn't follow the instructions and you're supposed to submit or file your annual return? Or is that not a contravention of the Act? It's just that something that you failed to do. So that is another problem. When is it a contravention and when is it not a contravention? And then the third thing we've seen so far, at least, is that the courts have insisted that there must be a very definite link, a causative link between the contravention of the Act and the damages that the person suffered. So you can't just say this person contravened the Act, and as a result, through a series of things that happened afterwards, I suffer damages. It has to be a direct link between the contravention of the Act and the damages suffered by the person who claims damages, and that is not so easy. So there have been very, very few cases where anybody has succeeded in obtaining damages for a contravention of the Act in terms of section 218(2). Remuneration, I don't think I have to deal with that because you've done your assignment question. One of your assignment questions dealt with that. You will see that the courts are really unhappy about the excessive fees that are often charged by the business rescue practitioners. You may remember in the newspapers there was quite an outcry about the high fees and costs paid to the South African Airways practitioners. I think in the end it was something like 18 million rand that was paid to the practitioners, not just for their fees, but also for costs, appointing consultants, etc. Also in the case of the Edcon group, there was also some complaints about the high fees. And it is true that the business rescue practitioners in many cases abuse section 143(2) to increase their tariff, which they're not allowed to do. And that was why I asked that question, because that question on the fees, that was taken from an actual case. I just changed a few of the, I changed the names and a few parts of the thing, of the quote, but it was basically that what the practitioner said. So they used section 143(2), which is a provision for a contingency fee, which has to be approved specifically by creditors and shareholders, they use that to increase their daily tariffs, in spite of the fact that Section 143(1) and the regulations are very clear about the fact that you may not increase your daily tariffs. Creditors, unfortunately, don't seem to be very educated or knowledgeable about this, so they just accept these excessive fees without making any or objecting to it in any way. So that is something, if you are acting on behalf of a creditor or a shareholder, that is something you have to keep in mind. Also, there is what is regarded as a gap or a weakness in the Act, is that the fees of business rescue practitioners, and there's no provision for the taxation of fees. Now, I'm not talking about income tax. Obviously, they have to pay income tax. The taxation I'm talking about here, for those of you who are not lawyers, that's in the case of a liquidation, and also in the case of court matters, if you are entitled to costs and fees, it must be taxed by them, in this case by the taxing master at the High Court, or in case of liquidation by the master of the High Court, who has the authority to deal with liquidations. And there they go through every item that you charge for, and you have to, if it doesn't look right or if it looks suspicious, they will force you to reduce your fees. There's no such thing for business rescue practitioners' fees. So they can basically charge anything, and if the creditors don't object, and they don't really have much of an option there, because if it's not an increased fee in terms of 143(2), then there isn't much they can do about it. There's nobody to protect them against excessive fees. Okay, so you've dealt with all that. The other important case in this issue is the Diener case. In the case of Diener versus Minister of Justice, Mr. Diener was the business rescue practitioner. He still had fees payable to him when the business rescue was terminated and the company was put into liquidation. So he claimed his fees and costs from the liquidators. The liquidators refused to pay him because, firstly, they said you did not submit a claim. And that's one of the basic rules of insolvency law and liquidations, obviously, as well, that if you have a claim, you have to submit your claim to the liquidator with the necessary proof before we will accept your claim. You didn't do that. Mr. Diener's argument on that was that he is automatically entitled to his fees because of Section 135, which gives him a preferent right to his fees for the business rescue. The second argument of Mr. Diener was because in this case there was no money to pay him, because there was only one asset in the company, and that was an immovable property subject to security by the bank. So there was no money left to pay anybody else. And the court said, first of all, you have to prove your claim like anybody else. You're not automatically entitled to your fees and costs. Secondly, you don't have any preference in liquidation. That preference you have in terms of Section 135 is only for the duration of business rescue. You do get a preference right, but that right is to be paid out of the free residue. You cannot insist on being paid out of the proceeds of a secured asset before the creditor who holds that security is paid, because you cannot dilute the rights of secured creditors in insolvency. So I'm sorry, you cannot get paid. Mr. Diener obviously was very unhappy, and so were most business rescue practitioners, but that is the situation. The Supreme Court of Appeal made it very clear that there is no such thing as a super preference for business rescue practitioners in a subsequent liquidation. You have to fall into the queue like anybody else, and although you have a preference claim, it is still a claim that must be paid out of the free residue, and if there is no free residue, then you will not get paid. Then we also mentioned the Karatko case, which we think was a rather unfortunate decision. In this case, one of the major creditors in the business rescue undertook to pay that special contingency fee to the practitioners if they managed to get the business rescue plan approved. Now, unfortunately, our Act does not require independence from creditors as one of the requirements, but that doesn't mean that you should not have no conflict of interest. And you will see when you look at the grounds for removal of a business rescue practitioner, it simply says independence. It doesn't say independence from whom. So you should be independent from everybody else. And being paid a special fee, quite a substantial one at that, for achieving a certain outcome by one of the creditors just does not seem right. It seems like a clear conflict of interest to me, but unfortunately, the Supreme Court of Appeal did not see it that way and said that it was allowed because it didn't have any impact on the creditors, which I don't think is perhaps too narrow, because maybe it didn't make a difference to the amount that creditors would receive, but creditors can also be prejudiced in other ways. So their interest, there should not be any bias on the side of the practitioners. And I don't think that even no matter how ethical they are, you cannot really say with an absolute certainty that you will not be biased perhaps lean towards the advantage of that creditor who is going to pay you a huge amount of fees. So that is not quite, I think, the right attitude. But anyway, that is, as I said yesterday, if the Supreme Court of Appeal decides that 1 + 1 is 5, then no matter how sure you are that they were wrong, you are actually, unfortunately, stuck with that decision. Right, when we go to study unit 7, the business rescue plan, that is obviously the most important aspect of the business rescue. We did not have any provision for a rescue plan or any sort of plan in judicial management, which was the predecessor of our business rescue procedure, and that was regarded as a weakness in the system. I am not 100% convinced that it was such a weakness, because as long as you had the right person as a judicial manager who knew what he or she was doing, it gave them a little more flexibility. Now, with the business rescue plan, as you will see later on, once that plan has been approved, then you are stuck with that plan. So, in VR laser services, the court repeatedly stated that the business rescue practitioners acted unlawfully and recklessly by proposing a plan which they called a controlled liquidation of the company under the guise of business rescue procedures. Now, the Act does allow that. That's one of the goals of business rescue, that you don't have to actually return the company to solvency. You can actually have as your goal just to get a better dividend to creditors. So that really comes down to some form of liquidation, because you can only give them a better return if you sell the business or the assets. The idea being that you should sell the business as an entity, as a running concern, and then get a better price. But of course, that's not always possible. So the court here said that the BRPs had taken it upon themselves to liquidate the company while the business rescue proceedings were still active. This is unlawful. So the court came out very strongly in about that. But as I say, it's the Act itself that actually lends itself to this, and it isn't supposed to be the same as a liquidation, but we do see quite a lot of that companies use business rescue to liquidate the company rather than to use the liquidation procedure, because it's less formal, it's faster, and of course there is no control by any authority over business rescue. So there is no possibility of a Section 424 liability as you would find in liquidation. Accounts are not taxed, etc. So there is simply not the control that you have in liquidation, and that's what many directors specifically want. They don't want anybody to look too deeply into the affairs of the company. The prescribed contents of the Act in Section 150, the section prescribes a lot of information, much of it unnecessary or not clear or not always applicable to every company, which is why the courts at a very early stage said that if you the substantial compliance would be enough. Excuse me, somebody's microphone has not been muted. Please mute your microphone because we hear all sorts of external noises. Make sure everybody that your microphone is muted. Okay, so as I mentioned yesterday, Section 150 requires you to give a list of pre-commencement creditors, but not people who have claims that arose after commencement of business rescue, which seems to indicate that post-commencement claimants are not included in the definition of creditors for purposes of affected persons, which means they wouldn't have a vote because your vote is based on your claim. And if your claim is not in the plan, how will anybody know what your claim is? The business rescue practitioner will obviously know that, but nobody else. So there's no control really by other affected persons whether this vote is correct or not. But as you will see later today, there is a possibility that post-commencement creditors really do have a vote on the plan. Then we have the Hlumisa Investment Holdings case. The court here granted an interdict on the application by two major shareholders who said that Section 150 requires the practitioner to consult the management and the affected persons before drafting a plan, and the business rescue practitioner in this instance did not do so. So the court said that although the shareholders don't have a vote on the plan in this case, they still have the right to be consulted before the plan was prepared. I'm not sure whether Section 150 meant it that strongly that you really have to consult them and take into account their views, but that was the view of the court. So that means a business rescue practitioner has to be very careful and make sure that all affected persons are consulted before the plan is drafted. You need not necessarily follow their recommendations and their wishes, but you have to consult them and take that into account. Now, the Section 150 subsection 2 starts with a general provision that it must contain all the information that will assist affected persons to decide whether they want to support the plan or not. That's actually enough. It was completely unnecessary to have this long list of requirements in parts A and B and C in the Act, because very often much of that is not applicable to this specific case. Now, in the Absa Bank versus Golden Dividend case, the court said, well, how can you prescribe the contents of the plan, but there's no sanction if the plan does not comply with these requirements, because some plans are really shockingly bad, like one-pagers. But it doesn't matter if the creditors are prepared to approve such a plan, then it's fine. But that's how it is. The Chapter 6 in particular contains a lot of provisions where it says you must do this, you must do that, but it doesn't say what will happen if you don't. And this is one of them. So it prescribes the contents, but there's no sanction or consequence if the plan does not comply, not even substantially comply. Publication of the plan, I don't think that should be a problem. It's very clear that you have to, again, the business rescue practitioner is supposed to draft the plan and to publish the plan within specified periods. But if that doesn't happen, unless somebody takes him or her to court, there's no sanction. The business rescue doesn't terminate, which is what the court in DH Brothers said, but that's that's not correct, because that's not one of the grounds on which a business rescue will terminate. So there's basically no consequence, except that you will have to go to court on the basis, as for instance suggested in the Berry Plum case, where the court said, well, there cannot be a business rescue without a plan. So if the plan is not drafted and published within the required period, you can go to court to say, well, there's no reasonable prospect of a success here because there's no plan. And without a plan, you cannot have a successful business rescue. I suggested there that you should perhaps go to the company's tribunal with a complaint if the practitioner does not publish the plan within the prescribed period, because the tribunal is a much cheaper option and a much faster option, and because the members of the tribunal are experts, you usually get a very reliable answer or a decision on your complaint. Right, that would be study unit 7. Then we go to study unit 8, the business rescue plan approval and rejection. Now, first of all, there must be a meeting to approve the plan, consider and approve the plan. Now, all affected persons must be notified of this meeting, but if the shareholders' rights are not going to be affected, they don't have a vote on the plan, so I'm not sure why they have to be informed about this meeting, but anyway. Then remember that a subordinated creditor only has a voting interest equal to the amount independently and expertly valued that they could expect to receive if the company is liquidated. Now, in your study, in your textbook, we mentioned the case where it was argued that if you are a concurrent creditor, that automatically makes you a subordinated creditor. That is not correct. In our law, you only become a subordinated creditor if you contractually agree to subordinate your claim. And that's usually, in most cases, that would be things like a shareholder's claim, in a shareholder's loan account, where the shareholder agrees that he or she will only be paid after other creditors have been paid in full, or they've received at least payment of 70% of their claims, or something like that. That is a subordination, but it has to be done contractually. The practitioner must explain the plan at the meeting. He must give an opportunity for discussion, and very importantly, the representatives of the employees have the right to address the meeting before voting takes place, obviously to try and influence the vote that will happen. If the trade union believes that the company will survive and that jobs will be saved, if the plan is approved, then they can try to convince the creditors at this meeting that they should vote in favor of the plan. So there are very strict periods within which the meeting must take place, within 10 business days after publication of the plan, but you can ask for an extension. And I think in many cases, the meeting does not take place within the 10 days. Okay, so how do you have the plan approved? The Act requires more than, take care that it's not just 75% of creditors who voted who must approve the plan, but more than 75%. So it's 75% plus 1. But in the case of independent creditors, you just need at least 50%. So you don't need 50% plus 1, only at least 50%, but more than 75% of all creditors who voted. And then at least 50% of independent creditors who voted on the plan. Now, 75% is very high. We are, as far as I could establish, the only country where this percentage is so high. In most jurisdictions, the requirement is a simple majority. In other words, 50% plus 1 of people who voted. The closest to us is the United States, where they require a 2/3 majority. But what is important is that in the case of the United States, Chapter 11 reorganizations, the creditors do not vote in one group. They are classified in terms of their type of claim and their interest. So, for instance, secured creditors would be a separate class. Concurrent creditors would also be separated into different classes. So in each of those groups, you would require a 2/3 majority. In our case, we require more than 75% of all creditors who voted, and they all vote at the same time in the same meeting, including your secured creditors who have a vote for the full amount of their claim and not just the unsecured part. So that means a secured creditor whose security will not be affected by the plan and may not be affected by the plan unless the creditor has consented, that person still has a vote on that secured claim, which doesn't seem fair, and it is in contrary to our accepted principles in insolvency law, for instance. In insolvency law, a creditor only has a vote based on the unsecured part of his claim, not on the secured part, because that part of the claim is secured. You're going to get paid. Why do you have to vote on it? But for some reason, in the case of business rescue, secured creditors have a vote for the full amount of their claim and not just the unsecured part. Right, now, let's say the plan is approved by the required majorities. If the shareholders' interests are not going to be directly affected, they don't have a vote. If their rights are going to be affected, then there must also be a vote by shareholders where a majority of their voting rights will be sufficient. So there you only require a majority of votes. Now, you'll see in the Act in section 152, subsection 4, that once a business rescue plan has been adopted, it's binding on the company and each of the creditors of the company and holders of the company shares, whether or not such a person was present at the meeting or voted in favor of the adoption of the plan, or had proven their claims against the company. Now, I don't know why they have this provision of irrespective of whether they have proved their claims, because Chapter 6 does not provide for any proof of claims. There's no requirement that a creditor must prove his claim. There are no forms or prescribed contents of the claim, or how are you supposed to prove your claim. So it is actually not a requirement in business rescue for a creditor to prove his claim. So obviously it doesn't matter, and they should basically have left out that subsection. But anyway, they found it necessary to include that, as with so many other unnecessary provisions. Okay, so once the plan has now been approved by the creditors, and if appropriate or if applicable also by the shareholders, everybody is bound to that plan. Now you'll see, I think it was, let me just see where I mentioned the Iravan case. I think it could have been in the textbook that, well, I can't see it now, but anyway, it is mentioned somewhere that a creditor is bound to this plan because of this provision that even if the creditor did not vote or did not attend, even a creditor who didn't know that the company was in business rescue. It is assumed that they should know because it is a duty of the business rescue practitioner and the company to inform all creditors that the company has entered business rescue. But if for some reason they did not do so, and this creditor was not aware of the business rescue, even that creditor is bound. It's in the Eraven case. So that
It's
means...
on page 40.
Thank you very much. I know it was somewhere. Okay, so everybody is bound, whether you knew about it or not. Doesn't matter. You are. Oh yes, Eraven Construction versus Becker. Right, now the other thing is the Act does not provide for an amendment of the plan once it has been approved. In Kransfontein versus Corlink, the court held, it was the Supreme Court of Appeal, that a business rescue plan cannot be amended by the court because it has to be voted on by the creditors. So if you want to amend your plan, you actually have to call a meeting of creditors again and ask them to vote on your amended or new plan. Now, in Booysen versus Jonkheer Boerewynmakerij, the practitioners thought they had solved this problem by reserving the right for themselves to amend the plan if necessary without having to call a meeting again. And the court said, no, sorry, you can't do that. You cannot amend the plan. We're not talking about just dotting the I's and crossing the T's. We're talking about a proper amendment of the plan. You cannot do that without approval of the creditors. And the fact that you reserve this right for yourselves to amend the plan, that will make no difference whatsoever. Now, although that was stated quite clearly in Booysen versus Jonkheer, practitioners still occasionally try that trick to see if they can save themselves some time and perhaps try to amend the plan in a way that suits them better. Because quite recently, in the Mpumalanga division of the High Court, in a case, Arkomanzi Proprietary Limited, I'll mention that in your tutorial letter 103, again, the practitioners tried the same thing. They reserved the right to themselves in the plan to say that they may unilaterally amend the business rescue plan after approval, and the court again said, no, sorry, you can't do that. You have to call a meeting of creditors again if you want to amend the plan. You cannot just unilaterally amend it. Now, when we get to the effects of the approved plan, I think maybe, I see it's 3 minutes to 10. Let's quickly take the break here for 10 minutes, and then at, let's say, 10 past 10, we'll proceed, because then we don't break off in the middle of something. So we'll just have a short break now, 10 minutes, and then please be back at 10 past 10. Thank you. Okay, ladies and gentlemen, if you're ready, we can continue. Just as sort of an aside, I just noticed that I got an email from SARIPA, the South African Reorganization and Insolvency Practitioners Association, which is one of the accredited professional bodies, that they now have new disciplinary rules, or rules to rules about disciplinary proceedings, because that's one of the requirements to be an accredited professional organization, is that you must have a process for disciplinary process for your members if there are complaints. Because people tend to complain to the CIPC when they have problems with their business rescue practitioners, but actually the complaint should go to the professional organization of which this practitioner is a member, and that's what the CIPC does too. When they get a complaint, they refer it to that practitioner's professional organization to institute disciplinary proceedings if necessary. They must obviously investigate the complaint first to see whether they must remove this member or suspend the membership of this practitioner, or cancel the membership. The problem, of course, is that some practitioners then simply move to another organization, and sometimes the communication between the among accredited professional organizations is not very good, so that the next one doesn't know that this person has basically been kicked out of another professional organization. The other thing is that the CIPC, although they get all these complaints, they do not have the authority to apply to court for the removal of a business rescue practitioner in a specific case, which I think is a huge oversight, because they do get serious complaints and there's very little they can do about it. So they inform the professional organization, but if the professional organization decides that it's not serious enough, or they find that this person was not guilty, then they can let it go, and the CIPC doesn't really have the power to do anything about that. So I hope that one day they will amend the act and actually allow the CIPC to also apply to court for the removal of a practitioner, and not just affected persons. Anyway, but that's just as an aside. So now we have an approved business rescue plan. Everybody's bound, even if you didn't even know about it. And this approved plan cannot be amended. There is no provision in the Act for the amendment of an approved plan, but also not for the rejection by the court or the cancellation by the court of the complete plan, an approved plan. So it's no use you can try it. I don't know if anybody has, to apply to court for the approved plan to be set aside. I'm not sure if a court will be prepared to do that. Firstly, because there's no provision in the Act itself for something like that. And also, if you look at the argument of the court in Boysen versus Jonker, where the court said that approval of the plan is a democratic process. So if it's been approved by a democratic majority vote of creditors, then the court doesn't want to interfere. So I think they may have the same approach towards setting aside the full plan, unless, I suppose, there has been really serious fraud, or creditors have been misled or something like that. Maybe then a court will do that, but not just because a group, one or more affected persons, feel that they have been disadvantaged or prejudiced by the plan. But eventually, I'm sure at one point, maybe one of the Guptas will go to court and ask for an approved plan to be set aside, considering the fact that they are always very prepared to go to court. And then we'll have an answer to this one. But at the moment, it's uncertain, and we don't know what a court would do in such a case. Okay, Section 154 is the section that deals with the effect of an approved business rescue plan. Again, because you've already, the Act has already provided that it's binding. Section 154 is then really a repetition, except that it's not been well drafted, as with so many other provisions in this chapter. And so section 154.1 and section 154.2 seem to be in conflict with each other, because section 154.1 provides that a business rescue plan may provide that if the plan has been implemented in accordance with its terms and conditions, a creditor who has acceded to the discharge of the whole or part of the debt owing to that creditor will lose the right to enforce the debt. Okay, now if the plan says you're only going to be paid 5 cents in the rand, does that mean that you are not bound because you didn't accede? And accede, I don't know why they used that word, but anyway, it means to consent, to approve. Section 154.2 then says, a creditor may not enforce a debt owed by the company immediately before commencement of business rescue, except as provided for in the rescue plan. So on the one hand, the one says, if you haven't acceded, then, or if you have conceded, it's discharged. So obviously the converse would be if you have not acceded or consented to the discharge of your claim, whole or part of the debt, then you won't lose your right. And then section 154.2 says, well, you're all bound by the plan. We recently had a Supreme Court of Appeal judgment, Van Zyl versus Auto Commodities, which I will also put into your tutorial letter 103. This actually concerned the surety, and we'll talk about that again just now, but at least here the Supreme Court of Appeal said section 154.1 deals with whether you can, a creditor is able to enforce his claim against anybody. And in that case, the creditor must accede if the debt is to be discharged. In other words, if the debt is going to disappear. The court did say, we don't know exactly how you're supposed to accede, what is required to accede, to be regarded as having acceded to a discharge of your claim. It could be voting in favor of the plan, or it could be something in writing. Nobody really knows. But if it ever gets to that point, we'll have to look at the facts to see whether we can say that this creditor has acceded to the discharge of his claim, so the claim disappears. Section 154.2, on the other hand, the court said that only deals with the right of a creditor to claim against the company. So once a plan has been approved, the creditor may not enforce the debt against the company except as provided for in the plan. So if the plan says you only get 5 cents in the rand and the plan has been implemented, the creditor cannot, if let's say the company survives the business rescue and it becomes successful again, the creditor cannot come back to the company and say, well, you know what, you still owe me 95 cents in the rand for my claim, because you lose that right. You lose the right to enforce your debt against the company, except as stipulated in the approved business rescue plan. So you cannot claim the rest of that debt from the company. It's done. You have to accept that's all you're going to get. Right. That brings us to the topic of the consequences or the effect of an approved business rescue plan on sureties. You'll see there's a long discussion about the effect because the courts couldn't agree on whether a surety is also discharged from liability after the approval of the plan, considering the fact that the creditor may no longer claim against the company itself. What about the surety? Some courts said the liability of the surety will also disappear because in terms of our common law, The surety is or a suretyship is an accessorial liability. In other words, it is accessorial to the main debt. If the main debt disappears, then there cannot be a suretyship. You cannot be a surety for a claim that, or for a debt that no longer exists. Others said, no, clearly it was not intended to discharge the liability of the surety. The surety will still be liable for the unpaid part of the debt. One of the arguments for discharging the liability of the surety was also that in terms of the common law, if a surety has paid a claim on behalf of a debtor in terms of the suretyship, that surety has a right of recourse against the debtor, the main debtor. In other words, you can reclaim or you can claim the amount that you paid as a surety from the debtor. So the argument was, well, then once the plan has been approved and implemented, that debt can no longer be enforced. A pre-commencement debt can no longer be enforced against the company. That's an important point. Section 154(2) specifically refers only to a debt that was owed by the company at the time of commencement of business rescue. In other words, post-commencement claims are not covered by Section 154(2), which is one of the reasons why I always assumed that a post-commencement claimant does not have a vote on the plan because he or she is not bound by the plan in terms of Section 154(2). Section 154(2) only deals with the rights of, or the way that the fact that pre-commencement creditors are bound by the approved plan. So that was the other argument in favor of saying that a surety will also be discharged from liability. Now, after that, the various judgments and the differences of opinion, at last, although we could see that the Supreme Court of Appeal was sort of moving towards in the direction of saying that the surety will not be discharged from liability, we actually now have a case, Van Zyl versus Auto Commodities, where the Supreme Court of Appeal had to specifically decide on this matter and held that a surety will still be liable in spite of an approved and implemented business rescue plan. The surety will still have to pay the unpaid part of the claim to the main creditor. Now you'll see that in your study guide, the Zungu Elgin Engineering case is mentioned. That's also a Supreme Court of Appeal case that actually preceded Van Zyl versus Auto Commodities, where already the Supreme Court of Appeal said, if you as a surety pay the debt of the company to a creditor after commencement of business rescue, you are not bound to Section 154(2), because Section 154(2) only applies to pre-commencement debts. You are a post-commencement claimant or creditor because you pay as a surety, you paid after commencement of business rescue. In that case, you are not a pre-commencement creditor and therefore you are not bound by the plan. Section 154(2) does not apply to you. So you can actually, which is what happened in the Zungu Engineering case, the company successfully completed business rescue and then went back into business. And in that case, the surety claimed the amount that he had paid to the main creditor. He claimed that from the company and said, that's my right in terms of our suretyship agreement and also in terms of the common law. And the company's defense was, but in terms of Section 154(2), you cannot claim a pre-commencement debt from me. And there the court said, well, this is not a pre-commencement debt. This is a post-commencement debt because it only arises when the surety pays that debt to the main creditor, and this happened after commencement of business rescue. So this debt is not covered by Section 154(2). So that was already a step in the right direction. And then in Van Zyl versus Auto Commodities, the Supreme Court of Appeal said that a surety remains liable even after a business rescue plan has been approved, and Section 154(2) does not apply to a surety. It only applies to pre-commencement debts of the company, and it does not have, and that's also important, Section 154(2) does not cancel the debt. So you cannot argue that the suretyship is also cancelled because the main debt no longer exists. The main debt still exists. It's just not enforceable. Okay, I'm not going to answer the question now, so I'll answer later on. So the court said if the Section 154(2) does not provide that the debt will disappear. The debt is there, it still exists, but it's not enforceable, which is not the same thing. So you cannot enforce the debt against the company, but the debt still exists, so the suretyship still exists, so the surety can be held liable for the unpaid part of that debt. The Supreme Court of Appeal did not have to deal with Section 154(1), but as I said, the Supreme Court of Appeal said, well, somehow you have to accede to a discharge of your debt, but we don't know exactly how that is going to happen. In that case, if you have acceded to a discharge, in that case, the debt disappears. Then there's no debt anymore. But in the case of Section 154(2), the debt has not disappeared. It still exists, but you cannot enforce it against the company except in terms of the business rescue plan. But then, obviously, for obvious reasons, you can still enforce it against the surety because the debt still exists. So now, at last, after all these years, we have the certainty on that. So sureties are still liable. It's still a mystery why the Act did not make any provision for the liability of sureties, because it does. In Section 155, dealing with compromises, it specifically says that the surety will still be liable. Why they didn't repeat that same provision in the sections dealing with business rescue, nobody knows. But anyway, now we know that the suretyship does not disappear and the surety is still liable. And the surety can enforce this payment against the company if the company returns to solvency and carries on business. Then the surety can still claim the amount that the surety paid on behalf of the company from this company after the company has emerged from business rescue. Right, so now that these provisions all deal with the effects when the plan is accepted and approved by the required majorities. Now we get to the effect of rejection of the plan. Now, this is really a question. Why did they chose to make the requirement for approval very high? More than 75% of the creditors must approve. And then they have all sorts of cunning little plans to get that majority vote against the plan. If they don't get that high majority, then they have all sorts of ways to try and get the votes, the majority votes rejected if they do not approve the plan, if they reject. So in other words, if you cannot reach that 75%, it would have been much simpler to simply make the requirement 50% plus 1, simple majority. That would have been much easier to obtain approval of the plan. Now they make it difficult to obtain approval by saying you need more than 75% of the votes, and then they have to have all these provisions trying to get the plan approved if they cannot reach that high level of approval. So it's really a problem that was created by the legislation itself, and now they have to find solutions. So what can you do if the plan is rejected? Well, you can obviously accept that as the business rescue practitioner, and that will be the end of your business rescue. The business rescue basically automatically ends if your plan is rejected and nothing else is done. You don't try to amend the plan, and you don't use any of the other provisions. Then your business rescue comes to an end, and you have to inform the CIPC by filing a notice of termination that your business rescue has ended because the plan was rejected and nobody did anything else to solve this. So because the first thing you can do if the plan is not approved, if it's rejected, is that the creditors can ask the business rescue practitioner to draft a new plan with amendments as they want it to be, which they may possibly then approve. That's the first possibility. But if that doesn't happen, there are two other ways of trying to get the plan approved. The first one is to apply to court to have the votes rejecting the plan set aside as being inappropriate. Now, in a very early case, I think it was a Gauteng High Court decision, the judge was very unhappy about this calling a vote rejecting the plan inappropriate, because he said, if you as a creditor vote against the plan, that is your personal opinion and that's your right. If you don't think that this plan is in your best interest, how can anybody tell you that voting against the plan is inappropriate? It's your right to vote against the plan if you don't think it's a good plan. But you'll see that there's been a change in that approach. So you have a case, for instance, the Copper Sunset trading case mentioned in your study guide, where the court set aside the votes of the first respondent. This was SPAR. They held more than 50%. I think substantially more than 50% of the claims against the company. SPAR and the second largest creditor both voted against the plan. So the plan was overwhelmingly rejected. Then the company went to court and asked for the votes of these two major creditors to be set aside as inappropriate. And much to their surprise, the court actually granted this order and set aside their votes. And so, because their votes were eliminated, the plan was now approved by a very small minority of creditors who had voted in favor of the plan. The court was very critical of the practitioners and told them that they was being unreasonable and self-serving and gunning for liquidation. But the fact of the matter is that this company was in fact liquidated within 2 years after this case. So the creditors were actually correct in thinking that this business rescue plan is not going to work, but the court was critical of that, and so but in the end the company was liquidated anyway. In the Shoprite case, the court said that you must look at whether the vote by the creditor against approval of the plan, it was done in good faith and it was reasonable. Because if it was reasonable, you cannot really criticize the vote as being inappropriate, because the creditor is protecting his own rights. And you'll see that in the JVJ Logistics case, the court also said that you cannot regard the vote as inappropriate where the plan would have the effect of placing almost all of the risks on the creditor. And you had that again, even by the Supreme Court of Appeal in the Normandy Restaurants case, where the court said an application to court to set aside a vote against the rescue plan is not just for the asking and will not be granted unless it can be proved that the opposing vote was unreasonable. However, then the Supreme Court of Appeal came out a year later with another view, the opposite view in the KJ Foods case. And here the court said you cannot just look at the vote of the creditor against approval of the plan in a subjective way. In other words, you cannot look at it from the viewpoint of the creditor. You must look at it objectively, and you must take into account the interests of all the affected persons and stakeholders. And you must decide whether it is just and reasonable to set aside the vote because it is not in the interests of all these people. So a creditor cannot just vote based on what he believes to be his own best interest. He must take into consideration the interests of all affected persons and all stakeholders, especially employees. So if a plan is rejected and there are employees, then the court is more likely to set aside this vote as inappropriate. Now, the problem with the KJ Foods case was that by the time the case came to the Supreme Court of Appeal, several years had already elapsed and the plan had actually proved to be fairly successful. And apparently the courts don't look at whether it is reasonable to vote against the plan at the time that you vote. They look at the results of the plan or the results of your vote at the time of hearing the application and having to decide whether to set aside your vote or not. So even a plan that looked terrible at the time of voting, and it was quite reasonable to vote against it, if it turns out 2 or 3 years later, by the time the case gets to the Supreme Court of Appeal, that the plan somehow did work out, then your vote is set aside as inappropriate because the plan apparently worked out. Which Henoksburg also criticizes because he feels you should look at it at the time the voting took place. If the vote was inappropriate, the time at which it was appropriate should be when the voting took place and not what you know now 2 or 3 years down the line. But that's not what the courts believe. I mentioned there the case of Naidu versus Michau, where there was also an application for setting aside the votes of creditors. And the court went back to that very first Supreme Court of Appeal case, the Oakdean Square properties, where the court said if the vote against the plan, or at this stage it was actually the beginning of the process, if creditors express the view that they are against this business rescue and they are going to vote against the plan, if they are not being unreasonable, you cannot just ignore their views. You have to take that into consideration. So the court referred to that, but also to the minority judgment in KJ Foods. I think there's a mistake because in the minority judgment was actually that it was reasonable, and the creditors could not be blamed for voting against the adoption. So the application for setting aside was dismissed. I'll just have to look at that again and just rectify that. However, all that is now basically of academic interest, because recently the Supreme Court of Appeal, in the case of Transnet, trading as the Transnet National Ports Authority, followed the approach of the decision in KJ Foods, where it was held that you cannot just look at the decision to vote against the plan as subjectively from the viewpoint of the creditor who voted against the plan. You must take into account the interests of all affected persons, all the stakeholders. So it must be an objective test looking at the situation to decide whether it is inappropriate in that it is against the interests of the whole group. So you cannot be selfish and just vote to protect your own interests. You have to look at the interests of all the affected persons. Now, in the Ferro-Staal case, it so happened that there were no employees. Also, there was no real business. This the company that was in business rescue, Ferro Marine Africa, it had no employees and it didn't really have a business. The only business and asset it had was a rental contract, in terms of which it was renting or leasing a piece of property in a harbor. I think it was Durban Harbor, which they then sublet to others. So their only income and business was subletting this property, which they were leasing from Transnet to others. But this obviously did not cover their costs, but they had no employees, and that the Supreme Court of Appeal regarded that as important, that they had no employees whose interests had to be protected. And so the court held that the vote of Transnet against the approval of the plan was not inappropriate, because there were no other interests to protect. In actual fact, Transnet was the only creditor who voted on the plan. There were two other creditors, but these were the two shareholders, the companies holding shares in the Ferro Marine, and they discharged their claims, or they retracted their claims, so they did not claim. So the principle has now been accepted and settled that a creditor's vote will be regarded as inappropriate even if the creditor voted to protect his own best interests, if it is not in the best interest of all the affected persons and all stakeholders, in particular employees, because business rescue is supposed to have one of its main purposes, although it's never mentioned in the Act, but it is supposed to save jobs. Right, so that is the principle that we will now have to live with, that you cannot just vote to protect your own interests. You can still do that, but then if somebody takes you to court and applies for your vote to be set aside as inappropriate, it is quite possible that your vote will be set aside. But in this case, another issue came up. Now, as I said, there was only one creditor who voted, and that was Transnet. There were no other creditors. The problem is that Transnet's claim was for arrear rentals, but these were all post-commencement payments that were in arrears. By the time this plan had to be voted on, I think Ferro Marine owed Transnet something like 40 million. The Supreme Court of Appeal accepted that Transnet could vote on the plan, although Transnet was voting on a post-commencement claim. And up to now, there had always been doubts whether post-commencement creditors can vote on the plan, because they're not bound by the plan in terms of Section 154(2). So can they vote on the plan? Hinoxburg believes they can. A senior counsel the other day in a webinar on business rescue said he believes they can't. The cutoff point is the commencement of business rescue. If you're not a creditor at commencement, you are not included in the definition of a creditor, which means you're not an affected person. You cannot vote on the plan, because it isn't fair that you can vote on a plan, but you are not bound by that plan. But anyway, the Supreme Court of Appeal didn't even mention it, because for some reason, none of the parties raised this objection that the vote rejecting the plan was the vote of a post-commencement claimant. So the Supreme Court of Appeal either did not recognize the fact or did not raise it because it wasn't raised by counsel on either side, or whether the Supreme Court of Appeal has in fact now accepted. Sorry, somebody's microphone is not muted. Please just mute your microphone. So, in other words, we don't know. Has the Supreme Court of Appeal now accepted automatically the principle that a post-commencement claimant, because you will see that a post-commencement claimants are never called creditors. If you look at section 135, setting out the ranking of post-commencement claims, it refers to the providers of post-commencement finance as lenders. It doesn't call them creditors. It doesn't call the employees creditors. So the Act never refers to creditors, to post-commencement claimants as creditors. But because the Act does not define creditors, we don't know whether they had that in mind or not. Anyway, so now the question is, did the Supreme Court of Appeal actually just assume that post-commencement creditors have a vote on the plan? Or did they not realize that this claim is post-commencement and there is some uncertainty about whether they do have a vote on the plan or not? Or did the Supreme Court of Appeal just not raise this because it wasn't raised by counsel on either side? We don't know. So the matter is not completely settled, but I would think that in future, if you have a post-commencement claimant, like the lender of post-commencement finance, insisting on a vote on the plan, then you can use this Supreme Court of Appeal judgment to say, well, there the court accepted the vote of post-commencement creditors or post-commencement claimants. The fact, of course, the matter, of course, is that if you didn't allow Transnet to vote, there was nobody else to vote on the plan because there were no creditors, no pre-commencement creditors who had claimed from the company who had submitted claims. So either you accepted the votes of Transnet or there was no vote and then there was nobody to approve the plan. In this case, of course, Transnet rejected the plan. And the Supreme Court of Appeal refused to set aside their vote. But it has now raised this other uncertainty. Are post-commencement claimants also included in the definition of creditors? In other words, do they have all the rights of affected persons, including the right to vote on a plan to which they are not bound? Or is that sort of not decided because it didn't matter anyway, because in this case, to a certain extent it did, because their vote against the plan resulted in the rejection of the plan and the court upheld that. So the court did not set aside their votes. So it's added that uncertainty, unfortunately, to the matter. But now we know at least that the approach adopted by the Supreme Court of Appeal in deciding whether a vote against the plan should be set aside is an objective test, and they look at the interests of all affected persons, especially the interests of employees. Right, so that's the one possibility. You apply to court and you have the vote set aside, the vote rejecting the plan, and then once that vote has been set aside, although the Act says then you must reconvene the meeting, the courts all agree that's nonsense, because if you reconvene the meeting, everybody's going to vote the same way they did before, and then you have a problem again. So once the vote of the opposing vote or the vote rejecting the plan has been set aside, so that the majority that is left is now in favor of the plan, that's the end. The plan has been approved. You don't have to have another meeting again. Okay, so that's plan A, what you can do. The second possibility is a binding offer to purchase votes. So what the Act states is that if the plan is rejected, affected persons may make a binding offer to the creditors who voted against the plan and offer to buy their votes. Now, immediately, this provision gave rise to serious problems, because the question was, binding whom? If you say they make a binding offer, who is now bound to this offer? Just the offeror or also the offeree, the person to whom this offer is made? In our law up to now, it's been accepted that a binding offer means that the offeror is bound, so he cannot retract his offer. He has to give the offeree the opportunity to accept or reject. However, originally or initially in the African Banking Corporation case, the judge held that the offer was not only binding on the offeror, but also on the offeree. In other words, if you vote against the plan and an affected person comes to you and tells you, I'm going to buy your vote so that I can vote in favor of the plan and get the plan approved, you cannot refuse. As long as they offer to pay you the liquidation value of your claim, that's it. As the offeree, you are also bound. So you cannot refuse this offer. Now, in the African banking case, they did not really follow the requirements of the Act of having the votes independently verified and valued. They just said, your vote is worth, I think they said 10 Rand. So they went around and gave 10 Rand to every creditor who voted against the plan and said, okay, and now we've bought your votes and now the plan has been accepted, which obviously was an abuse of the process. So the matter was, okay, then we had the DH Brothers Industries case where the opposite was held. Here, the Judge Gorvin said that the offer was binding only on the offeror and could not be retracted, but it could be rejected by the offeree. Eventually, the African Banking Corporation case was taken on appeal, and the Supreme Court of Appeal said that the offer is not binding on the offeree. So the offeror is bound and cannot retract this claim, this offer, but the offeree has the freedom to reject the claim, the offer, or accept, depending on what he feels like, because there are certain advantages, such as the fact that you are paid immediately. You don't have to wait for a whole liquidation process to go on because the plan has been rejected. But if they don't offer you enough, you can say, sorry, I'm not accepting your offer, and then the plan will remain rejected, and that will be the end of the business rescue. So at least in that case, I'm not quite sure whether that was what the drafters had in mind. I think they wanted the offeree to be bound as well. That's why they have this whole process of evaluating the liquidation value of the creditor's claim, and that is the amount that must be paid to you. But the Supreme Court of Appeal has decided that that is not acceptable, or they don't think that's what was meant, and so only the offeror is bound by the plan, by the offer, but not the offeree. The offeree has the freedom to either decide to accept it or reject it. Okay, that is then Study Unit 8. Study Unit 9, Termination of Business Rescue Proceedings. Now, Section 132.3 provides that if the business rescue has not ended within 3 months after commencement, then the business rescue practitioner must either ask the court for more time to finalize the rescue, or otherwise prepare a progress report at the end of every month, and this must then be delivered to every affected person and the court if the proceedings have been the subject of a court order, but otherwise to the CIPC. I don't think the courts will know what to do with this report. So basically, you just report to the affected persons and to the CIPC. The CIPC has started being very, very strict about these reports, because most business rescue practitioners simply ignored it, because once again, there is an obligation, but there's no sanction or penalty if you don't do it. So they just ignored it. Then later on, those who did submit a monthly report simply said, there's nothing to report, or there's been no progress, or we're still waiting for post-commencement finance, nothing else. Now the CIPC has started acting on inadequate or reports that are not submitted. If you don't submit your report every month, they will lodge a complaint with your professional organization because they say it's a contravention of the Act. And also, if you do not submit a proper report saying exactly where you are now, why it's not finished, and what you are doing. Now, 3 months is not a very practical period. It's much too short. Even fairly simple business rescue proceedings take at least 6 to 8 months. So I don't know why they decided on 3 months, but anyway, that's what they said. So it is very important for business rescue practitioners to submit these reports every month to say exactly what is going on and how far the business rescue has progressed, because sometimes these proceedings just drag on, nothing happens, but the practitioners keep on charging their fees, their daily fees, for whatever they have done, even if they don't seem to have done anything much. And they just don't terminate the business rescue or submit any report. So, as I said, the CIPC has now started being very strict about the fact that you have to submit a proper report every month after the 3-month period. Right. The other way in which to terminate business rescue proceedings in terms of Section 132(2) is when an affected person applies for the resolution commencing the business rescue to be set aside, or even if you apply for the appointment of the business rescue practitioner to be set aside, the court can actually decide, you know what, this business rescue is a waste of time, it doesn't comply with the requirements, we're going to set aside the whole resolution, and that's the end. Secondly, if the business rescue practitioner at any stage during business rescue comes to the conclusion that there is no longer a reasonable prospect for the company to be rescued, then there is an obligation on the business rescue practitioner to apply to court, to say to the court, I want to terminate the business rescue, and I'm applying for the company to be placed in liquidation. That is an obligation on the business rescue practitioner. And then, thirdly, by the filing of a notice of termination. That is if you have business rescue proceedings that were commenced by a board resolution and the business rescue practitioner comes to the conclusion that this company is no longer financially distressed, then he must file a notice with the CIPC to say this is the end of the business rescue, the company can carry on doing its business and it's no longer necessary to keep it under business rescue. The other notice of termination is a bit problematic because when you look at the setting aside of if the business rescue plan has been rejected and nobody does anything, then the Act says that the business rescue practitioner must file a notice of termination. But the Act also says that if the plan has been rejected and nobody does anything, business rescue ends. So the question was, does it end the moment the business rescue plan is rejected and nobody decides to do anything? Or does it only end when that notice of termination is filed? And the court has now come to the conclusion that if the plan is rejected and nothing further is done, so nobody asks for an amendment, nobody applies to court for the setting aside, nobody makes a binding offer, then the business rescue ends at that point. So it does not require submission of the notice to the CIPC. That notice is for administrative reasons so that the CIPC knows that this company is no longer in business rescue. And so the business rescue has ended, but the business rescue the business rescue actually terminates before the filing of that notice. There are previous judgments where the court said, no, it only ends when you submit or file that notice of termination, but it seems as though the provision that states that it ends when nobody does anything after the plan has been rejected, that is the strongest provision, and therefore it ends at that point in time, which is not always all that easy to determine, because it may take a day or two for somebody to decide, maybe I should actually go to court. I do have a few days, and I think I'm going to apply to court for it to be set aside. So you can't be sure that nobody's going to do anything, but if the moment the business rescue practitioner comes to the conclusion that nobody's going to do anything further, it's probably better to immediately file that notice of termination, so that the CIPC knows that you are no longer the business rescue practitioner, because there is no business rescue, and so you cannot be held liable for anything that happens afterwards. Okay, I see that it's 11 o'clock. Let me quickly just talk to you about the compromise with creditors. Now, some people seem to confuse the compromise in section 155 of the Act with business rescue. It's not the same thing. These are two completely separate processes. The compromise, you cannot enter into a compromise if a company is in business rescue. You can only have a compromise with your creditors or some of your creditors if the company is in liquidation, or if it is still running the business, if the business is still going on. Then you can make an offer to your creditors or a class of creditors for a compromise. In other words, that they will give you more time to pay your debt, or that they will be prepared to discharge part of their claim, so that you don't have to pay them the full amount. So it's a much more informal procedure. It's done by the board if the company is not in liquidation, or if the company is already in liquidation, then the liquidator can make that offer. And if it is approved by the required majority, and here again you have the 75% requirement, then you have to actually, the Act is not very clear about it, but if you read the whole thing in context, you'll see that you will then have to go to court to ask the court to sanction this compromise. And once this compromise is sanctioned by the court, it will be binding on all creditors, or all creditors of that class, even those who voted against the compromise, as long as you got the necessary majority vote approving your compromise. It must also at least 75% in value of the creditors must vote in favor of the compromise. Now, this section actually replaces Section 311 of the previous Act, or at least part of it. Section 311 provided for a compromise with creditors, or also an arrangement with your shareholders. In the new Act, they have separated the two. So Section 155 is only deals with compromise with your creditors. Although the Act does not say so anymore, the previous one did, that if your company is in liquidation, you can make it a condition of your compromise that the company's liquidation order will be set aside. I'm sure you can still do it, because otherwise there would be no sense in a liquidator entering into a compromise with creditors. So the purpose would be, if you can get the compromise approved by the required majority of all creditors, then you can apply to court for the setting aside of the liquidation order, and the company will then be able to carry on doing its business, which is then basically the same result as business rescue, as a successful business rescue, except that you don't have as many requirements and formalities, and it's cheaper because the liquidator can do it, and you don't have to appoint a business rescue practitioner. Okay, ladies and gentlemen, that is all I have to say. Now it's your opportunity to ask questions. Is there anybody who would like to ask questions? Let me see. Nothing. Let's see. No, it doesn't look like I have any questions. Are there no questions whatsoever? It's all absolutely clear to you? No, doesn't look like it. Okay, and no hands are up. Okay, here's a question. Yes. Come on. How many questions will we ask? It's long questions, I can tell you that, because these are problem questions. So questions can count anything from 10 to 30 marks. How many questions there will be, I have no idea, because I have not drafted the exam paper again, but in previous years it differed sometimes, because the total of the paper is 80 marks. It counts 80 marks. So sometimes I had a question of 30 and then 2 of 25, or sometimes I had a question of 40 and then 20. So it depends on the type of questions. So I can't really tell you how many questions there will be, but it would be long questions. It's really only if there's a very small gap to fill that I would ask a 5-mark question, but that's unlikely to happen. Okay, any other questions? Right. What does a business rescue plan look like? The only people who really know what a business rescue plan look like are the business rescue practitioners initially, because the business rescue plan is never filed with the CIPC. So the CIPC doesn't even know what the plans look like. Initially, the business rescue practitioners were very jealous about their plans, and they kept it very confidential, because although the act gives you a whole list of requirements, it doesn't actually show you what it looks like. And then the practitioners said, well, we had to put in a lot of work to draft our basic plan, the template. In other words, so we can't really we don't want other people to see it. But I won't ask you to draft a business rescue plan, because that is a practical matter, and I think that is something you can only learn to do when you have to do it. But basically, if you ever have to draft a plan, if you don't have a template or an example, basically what you do is what the Act requires you to do in section 150. You give a list of creditors, you say what their claims are, you say whether they are secured or preferent creditors, you make a list of the assets and their value, and then you basically say what you're going to do. So some plans run into hundreds of pages when it's a very complicated case. Others are just a few pages. So it depends very much on the circumstances. But there is no prescribed format, as long as you have the basic requirements in your plan. And as I've said, the courts accept that you only have to substantially comply, because not everything in section 150 applies to every company. So in the more complicated cases, you would have a report by auditors to say what the financial statements are and what the chances of the company are. And then in others, you won't have something like that. Okay, so let me see. So I think business rescue practitioners are a little bit more prepared to give you an example, but not the complicated ones. You will see some of the bigger cases where the company is in business rescue. There is a website where the practitioners post their reports and also eventually draft plans. So you can actually perhaps look for the bigger cases and see if there are examples of business rescue cases. One of the very first ones, but I'm not sure if that website is still available, that Aeronautique case, there they actually published their draft plan on the internet. So it may be worthwhile to just go through or basically Google the big business rescue cases and see if you can find a plan. The creditor, no, the creditor can pursue the surety whenever. There's no reason why because that's what I said. The surety is not bound by, or is not, the suretyship is not affected by the plan. So in other words, you can claim, the creditor can claim from the surety for as long as that suretyship exists. If a company in liquidation has the potential to be rescued, what would the court require to be convinced to rule in favor of business rescue? The basic requirements that you find in the Act, in Section 131. In other words, the court will obviously accept that this company is financially distressed because that's why it's in liquidation. Your difficult hurdle would then be to prove to the court that the company has the potential. There is a reasonable prospect of rescue, which would be that the company can be rescued and can survive and continue to exist in a solvent state. I don't think the court will be very keen to end liquidation and order business rescue if you base your business rescue application on the second objective or goal of business rescue, namely that you can get a better dividend for creditors, because the court will say, well, the liquidation is already in progress. It will depend, of course, on how far the liquidation has progressed. But that will take more convincing. But if you can prove to the court that this company has the potential to survive after business rescue, but then it will depend on the circumstances. If a new opportunity arises, or the economy has improved substantially, or this type of business, there's a need for this type of business. So it will be a matter of proving to the court that this company can survive if it's put into business rescue. Okay, I will not expect you to draft a business rescue plan because it will take too much time, and we haven't really trained you to do that. So no, we will not expect you to prepare a business rescue plan. Our question would rather be from the other side. This is what the business rescue, not a full business rescue plan, but one of the provisions in the plan is to say this and this. Is this correct? Is this acceptable or not? Because our emphasis is on the law. So it's not so much on the practical the practical aspects. Okay, how do you go about entering the business rescue profession? That is a difficult question that is very often asked, because it is a problem to get into the profession. Your best bet is actually to work for an established business rescue practitioner, a senior or an experienced one, because then you can be co-appointed to bigger cases where you would not be appointed as a junior. Otherwise, it's a lot of networking, but it's difficult to get your foot into the door. Your best option is actually to work for work with a senior or experienced practitioner, so that you can get appointments as a co-practitioner, and that's how you establish your reputation. Because in the end, it's usually the attorneys who advise their clients whom they should appoint as business rescue practitioners. So another piece of advice I can give you is to join the professional organizations such as SARIPA. TMA South Africa has a lot of requirements for joining. I think you actually have to write all sorts of exams, but SARIPA doesn't. So that will help you with your networking as well. Okay, let me see what else. New messages. Yeah, EDCON, that's right. The EDCON plan is one of the bigger ones that was published on the BRP's website. So have a look at the EDCON. That, of course, is quite a complicated plan, but it will give you an idea. Oh, and there's another one, Group 5, South African Airways. There you go. Okay. You've been approved as a business, you've drafted the plan, it's been approved, then you have to implement the plan. And that is what the Act requires you to do. You cannot terminate the business rescue until there has been substantial implementation of the plan. The Act doesn't tell us what substantial implementation is, so it's basically a matter of opinion. The best plan or the best solution is to put that into your plan, to say, or this plan will be regarded as having been substantially implemented after such and such has happened, after the creditors have been paid in terms of the plan, or until they've been paid 80% of their claim in terms of the plan, whatever. But it's actually better to have that set out in your plan, because otherwise it's open to interpretation and nobody's really sure what could be regarded as successful or a substantial implementation. And until you reach that point, as a business rescue practitioner, you may not terminate you're not allowed to terminate the business rescue. So that's your best protection, so that you can step away and end this thing once you feel that you've done your job. Okay, right. Is that it? Thank you very much, everybody. I'm sorry we had to rush through this so quickly, but at least hopefully when you go through your preparations, some of these things will ring a bell. And as I said, I am going to make tutorial letter 103 available, probably by Friday, where I will give you the names and the details of the additional cases, the new cases. Thank you very much. That's it then. Okay, goodbye, and thank you for joining. Thank you.